We are moving on to the third panel of our conference, and I would like to ask Dmitry to introduce the chair of the third panel, Islambek Rustambekov. Dmitry, over to you.
I am very glad to introduce Professor Islambek Rustambekov, who is Vice Rector of the Tashkent State University of Law, Doctor of Law, Professor of Private International Law Department. He specializes in private international law, international investment law, international commercial and investment arbitration, mediation, recognition and enforcement of judgments of foreign courts and arbitration awards. And it should be mentioned that he is designated member of the arbitration panel of the International Center for Settlement of Investment Disputes, ICSID, from the Republic of Uzbekistan, and listed in the lists of arbitrators of important arbitration centers. So Islambek will be moderating our panel, and now the floor is yours, Islambek.
Thank you very much, Dmitry, and thank you for giving me the floor. And dear distinguished guests and participants, honorable panelists, welcome to the second day of the CIS-related Disputes Conference, and welcome to the third panel on enforcement and of foreign judgments and arbitral awards in the region. As Dr. Davydenko mentioned, I'm Islambek Rustambekov, Vice Rector of Tashkent State University of Law, and I'm also international arbitrator, and it's a great privilege and honor for me to be here and moderate this session. I would also like to extend my deepest gratitude to today's speakers, Dr. Dmitry Davydenko. Dr. Davydenko is the director and co-editor of the CIS Arbitration Forum. He is an associate professor at the Moscow State Institute of International Relations, MGIMO University, Department of Private International and Civil Law, and Higher Court of Economics. He is included in the list of best practitioners in arbitration in Russia as of the years 2017 to 2021 by Who is Who Legal and Global Arbitration Review. Dmitry Davydenko has experience as an arbitrator in the ICC and other arbitral proceedings and is listed as a recommended arbitrator of the International Commercial Arbitration Court, Maritime Arbitration Commission, at the Russian Chamber of Commerce and Industry and other reputed arbitral institutions. Executive Secretary of the Expert Council under the ICC Russia Commission on Arbitration. He also acts as a Russian law expert on various matters related to international commerce. Ms. Maria Gritsenko. Maria is an Associate General Counsel Litigation at the Amsterdam headquarters of VEON, a telecom company with operations in emerging markets. Also, she is interim head of legal for the Kyrgyz operating company of VEON. Headquarters role involves managing major disputes across the group, international commercial and investment arbitrations, court proceedings, as well as managing and assessing legal risks more generally. Prior to moving to VEON 2.5 years ago, she had 10 years in private practice in London. Also, we have Mr. Richard Brown. Richard is a BVI litigation partner with Carey, Olsen, based in London. His practice covers all aspects of BVI litigation and insolvency, in particular fraud and asset tracing and shareholder disputes. He regularly acts in disputes involving parties in the former Soviet Union. He is one of the authors of the PLC chapter on the enforcement of foreign judgments and arbitral awards in the BVI. The next speaker is Mr. Jacob Hubbard. Jacob is Senior Case Manager and heads the Frankfurt office of Nivelian, a Swiss third-party funder active in continental Europe, Asia, and the Americas. Before joining Nivelian, Jacob worked for almost a decade as a lawyer in the area of litigation and arbitration in several US law firms in Germany, with a particular focus on clients from Russia and the CIS region. Jacob is admitted as a lawyer in Germany. In addition to a law degree from the University of Frankfurt, he also holds a degree from the University of London. He speaks German, English, and Russian. And thank you, dear distinguished speakers, for joining us. I would like to make some brief introduction of the panel's topic. And it was already mentioned some issues of the enforcement and recognition of foreign judgments and arbitral awards. But the issues in the mechanisms for recognition and enforcement of foreign court judgments and arbitral awards is very actual in CIS countries, because most countries doesn't have clear legal regulations or practices that consider the interest of the plaintiff, defendant, and state. It is important to strengthen and improve the legal framework for recognition and enforcement of foreign judgments and arbitral awards. It is necessary to understand the effects and implications that recognition and enforcement of those decisions have in the international judicial system. In international practice, there are often situations where a court resolves a dispute in favor of a party located in another state. The rendering of such decisions then requires that the decision be recognized in other legal orders than often enforced in the territory of that other state. Typically, the purpose of such a procedure is to eventually seize the debtor's assets in the state. Having a strong legal framework and clear judicial practice in place for recognition and enforcement is crucial for CIS countries. In recent years, with the increases in the migration of citizens and foreign investment, these questions have become increasingly important. For instance, international arbitration is progressively becoming the most desired dispute resolution mechanism in international trade because it provides many benefits for contracting parties. Among these benefits is that arbitral decision can be recognized and enforced almost anywhere globally through international conventions. Understanding the legal framework and practice of recognition and enforcement of foreign judgments and arbitral awards, also improving the applicable legal framework, would increase trade relations between CIS countries and their relations with other countries. Our guest speakers of today's session are experts in international dispute resolution, and we are looking forward to listening to their opinions and experience and making conclusions afterwards. I also encourage everybody's active participation in discussions. Informed that all participants could ask the questions through that chat box which we have in the Zoom, and also use raise the hand function. So we will give the possibility to ask the questions or comment the discussions. And I wish all of you a constructive session. So thank you everyone for participating, and please enjoy the session, and we will begin. We have planned with our colleagues to not to speak just to speak about the topics, but we would like to have an active discussion. So because of that, I would like to ask the questions from the speakers. And I would like to begin from Dmitry. Dmitry, please, could you briefly inform us on the current trends as regards recognition and enforcement of foreign judgments and arbitral awards in Russia, and not repeating the previous discussion? Please, could you give us some brief information on that?
So, in my opinion, there are two contradictory interests of Russian authorities which they try to pursue. On the one hand, it is important to take part in international circulation of judgments, well, in supporting international business of Russian entities. So therefore, arbitration is also relevant. By the way, Russian authorities and the St. Petersburg Legal Forum confirmed that it's acute to work on electronic apostille, for example, and to ensure recognition of electronic signatures and official documents and so on. So this is important. Therefore, it's important to ensure the recognition and enforcement of foreign judgments as well. On the other hand, it's crucial for Russian courts and also for Russian authorities as such to gain and to have control and power over, also foreign judgments. Therefore, the toolkit, the trend is to have to strengthen the toolkit for this. As you well know, some amendments of the Russian constitution were directed to strengthen the protective mechanism against unexpected or unfavorable foreign judgments and arbitral awards. So Now it's on the constitutional level. And another such tool is in the Commercial Procedure Code, the Russian new type of anti-suit injunctions, where it is possible to neglect arbitration agreements in contracts in case they become unenforceable, in the sense that Russian companies suffer from insufficient access to justice abroad. So it's possible to lead these disputes here in Russia. But fortunately, currently our Russian courts do apply these provisions with caution. And today, later, Ben Wells will speak on this in detail. So one trend is to strengthen international cooperation, to enforce judgments based on reciprocity and comity. And another trend is to gain control in most important and sensitive cases.
Thank you very much. And what about the ease of the enforcement in Russian courts of the foreign awards? And maybe you have some statistics on that.
Statistic is not bad, really, not too bad. Now, as I see the statistics for the previous year, about 75% of foreign judgments and awards have been successfully enforced. This is the official statistics from the Russian system of courts and the Russian Supreme Court. And for example, 2 years ago, 4 years ago, it was less. It was about 66%. Now that it's 75%. So it's getting better. A few years ago, it was easier to enforce a domestic arbitral award than foreign. And now I think foreign is even maybe easier to enforce. But you need time and sometimes not one instance of courts, but you need some patience to do it finally to get success.
So there is a good progress. And Richard, maybe you could give us some information about the BVI courts. How easy it is to enforce an arbitral award in the BVI courts? For example, where the respondent to the arbitration is a BVI entity, or a respondent maybe entity from CIS countries which holds assets in the BVI. Please, maybe you can give some information on that.
Yeah, thank you. The key thing here is that, as I'm sure you all know, it's very common for businesses relating to the former Soviet Union to use BVI structures. So, for example, joint ventures will often be structured through the BVI, and the joint venture agreements will very often contain an arbitration clause to resolve disputes. And similarly, in financing deals as well, through Russian banks and Russian lenders, there will very often be agreements between BVI entities which are governed by arbitration clauses. And so as a result of that, the BVI courts are very familiar with seeing cases that relate to the enforcement of awards that are very closely connected with the former Soviet Union region. And the general approach of the BVI courts is a pro-arbitration approach and a pro-enforcement approach. And BVI has a pretty modern arbitration regime through its Arbitration Act 2013, and it officially joined the New York Convention in 2014, although before that there was still a streamlined procedure to enforce New York awards. And just very briefly, I won't go in too much into the detail, but there are two main ways to enforce an arbitral award, a foreign arbitral award in the BVI. The first is by registration, and that's following the usual New York Convention principles, whereby the award can effectively be enforced as if it was a BVI judgment after it's been registered in the territory. And the second way is a slightly different approach, is to use an unpaid award. So if there's an award has been rendered but not paid, that can sometimes be used as a basis to appoint a liquidator over the respondent, and the liquidator would then be responsible for getting in the company's assets and discharging all of the company's creditors, including the award creditor. I'll just very, very briefly describe how both of those processes work for those who aren't familiar with them. First of all, the registration procedure is a very streamlined procedure where you can take the award to the BVI court, and the court will, provided that all of the main criteria under the new convention are met, will register that judgment, and it can then be enforced as if it was a judgment rendered by the BVI court itself. That procedure can be done without notice to the respondent. And at that stage, if necessary, the court might grant interim remedies to protect the position pending service of the final registration on the respondent. But thereafter, you can obtain some very useful remedies for final enforcement, such as a charging order over assets held by the BVI entity, or the appointment of a receiver to effect the sale of the entity's assets in satisfaction of the award. And just briefly on the liquidation route, that can be invoked where the basis of the unpaid award is that the company is deemed insolvent because it can't pay its debts as they fall due. An appointment can then be made of a liquidator in the BVI, and the advantage of that is that the liquidator has very strong remedies, very strong powers to obtain remedies to get in assets. So it can sue former directors of the company, it can bring claims in the name of the company, and it can also seek recognition in foreign jurisdictions, which can obviously be very useful in international cases. And in my opinion, the use of liquidation proceedings to enforce an arbitral award can also be very effective in bringing about an early resolution, because if the respondent is a trading company, the existence of insolvency proceedings can make it very difficult for that company to continue to operate, because, for example, financial institutions may cut off credit lines, customers may be reluctant to deal with it. So that's often the best reason to pursue the liquidation route. So that's a very brief summary of the two routes that are available in the BVI.
Thank you very much. And what about the number of such cases related to CIS countries in BVI? Have you been interested in maybe some statistics also?
We don't, unlike your course, we don't actually have a particularly good statistical reference point. It's more anecdotal. And in fact, very often the court will give judgments without publishing the judgments. And so often the statistical information simply isn't available. But I can tell you from personal experience that it's very common for FSU-related arbitral awards to be enforced in the BVI. And there will come later, I might mention some of the more high-profile cases.
Thank you. Thank you very much indeed. And Maria, what do you think about the importance of enforcement prospects for in-house counsels? And how is this factored into the decision-making process? Maybe you can just inform us on that.
Well, Islambek, will you forgive me if I hijack a little bit this question? I will behave in a typical in-house counsel fashion and take advantage of, practitioners available to me for free right now. And I have a question which is arising out of the previous discussion on the BVI. Please. So if you don't mind.
I don't mind, please.
Dmitry, do you have any experience about the interaction of the BVI enforcement judgments and the Russian courts? So for example, imagine a scenario where you have an arbitration, as you say, between the BVI entities, right? And so it's enforced in the BVI, or there is a recognition of the award in the BVI. But the concrete steps to be taken to actually give effect to the award must be done in one of the CIS jurisdictions, for example, registration at one of the local chambers, etc. How does it work? Would the local court and the CIS acknowledge that the award is now recognized in the BVI and allow the party to proceed with those steps? Do you have any anecdotal evidence, statistics, any theory on that? I would be very interested.
Well, I don't have any statistics, unfortunately, for the reasons I said before. But again, anecdotally, I've certainly worked on cases where receivers have been appointed on the basis of an arbitral award, and those receivers have then been able to sell underlying assets certainly in Ukraine. I'm not aware of that happening in Russia, actually, although that's not to say it hasn't happened. But you're right to raise this point, because obviously although one of the advantages of taking enforcement measures offshore is that you can avoid some of the more political issues that you can encounter within the sort of state of origin, as it were. You're right that eventually you often do have to re-export whatever decision the BVI court takes, and that can be problematic. But having said that, I think that the key development in the BVI in recent years is that of appointing receivers, because receivers really do just take control of the company, and they have very wide powers to conduct the affairs of the company. And so although that doesn't necessarily give them an automatic right of recognition in wherever the actual underlying assets are, it is an incredibly powerful tool. And I've certainly seen it used to great effect in several cases involving the FSU.
Okay, thank you. So coming back to Islambek's original question.
Please, your comments.
Thoughts on the in-house perspective. Look, just taking a step back, I mean, obviously enforcement is very important. We're going to get back to that. But I would like everybody to remember as well that sometimes you can initiate proceedings while being fully aware that you will not be able to enforce them. And just, you know, the point, the fact of initiating may provide you enough leverage in the negotiations with the other party, because the other party may be sensitive to the fact of the existence of the proceedings, or even to the existence of the judgment against it. So don't discard the possibility of a litigation if you think the other party may be insolvent or may become insolvent or may dissipate assets. So this is just something strategic to keep in the back of your mind. But then obviously, generally, if you go into litigation, which is not a preferred course of action for many companies, we would prefer to resolve disputes amicably with our counterparts. But if we do go down that route, we would prefer to get a positive outcome and to know that 2, 3, 4 years down the road, after we spend all this money, something useful for the company will come out of it. So we look at it at various stages. And obviously, even when you conclude a contract and you insert a dispute resolution provision in your contract, you already have enforcement in mind, right? So you always try to provide for the forum, which would be favorable, you know, from the enforcement perspective. And for example, arbitration may be, from that point of view, actually easier in some cases than a state court, New York Convention, etc., etc. So it may be down the road, you may think it's easier to enforce. If you deal with parties, with state parties, or with state-owned parties, etc., you may want to insert a waiver in your contract, waiver from immunity from execution, etc. And you want to check local legislation that this party is actually authorized, for example, to sign an arbitration clause in the contract and won't create issues down the road. So things like that just at the first stage. Then once you initiate the proceedings, there are several things you look at. For example, if you're talking about court proceedings, you want to join all the right parties. We discussed that sometimes the contract is just with the shell companies, and will they have assets to actually enforce the judgment, actually execute the judgment you will get at the end. So you need to think whether there's any other party that you can and you're entitled to join. Obviously, it's more difficult in the arbitration context, but still, it's something to consider. And then when you actually, in the course of the proceedings themselves, and for example, if it's an arbitration, you also need to be careful. And even though it's not our primary job to ensure enforceability of any eventual award, it's the job of the arbitrators. But we also want to be mindful of that any steps we take or any demands we make of the arbitrators actually will not render any award unenforceable. And that's an important point for us. So that's, even as you can see, even from the onset of the proceedings and from the onset of the contract itself, enforcement is always present in the back of your mind, and you just take those steps and keep being considerate of that. Obviously, at some point, earlier or later, depending on the case, the question of assets comes into play. Is your counterparty solvent? Will it be solvent at the end of the process? And then sometimes, yes, asset search is a relevant consideration. Often, I think in practice, though, especially if we talk about commercial parties, you would know whether your counterparty has assets or where it has assets, etc. But then there may be other cases where you need some additional intelligence. And yes, some companies do hire specialized companies to locate potential assets, and that's also practice. Islambek, I think you're on mute.
Yes, thank you. Thank you very much. I just remembered one issue in Uzbekistan with the enforcement of the foreign awards, arbitral awards. There was one award against one company, but this company had an asset in Uzbekistan, but there is no registered entity in Uzbekistan. And the state courts were refusing to enforce because in Uzbekistan, there is such a practice that there is no entity in Uzbekistan, but there is an asset. The courts wouldn't enforce. They are not going to enforce because there is no company. And they're asking to enforce like this award in that country where the entity are registered, and then send maybe this decision of the court on the recognition and enforcement to Uzbekistan, and in this regard, the asset, like the enforcement, will be made also in Uzbekistan. So there's a very interesting situation, and maybe Dmitry and Richard could give their comments on such situations and tell about the circumstances or grounds on which Russian and BVI courts usually refuse to enforce foreign arbitral awards, and how is the public policy ground of refusal applied in these jurisdictions, please?
Yeah. Islambek, first of all, I'm glad to say that if a foreign company is not registered it's foreign, not registered in Russia, but has some assets in Russia, and if the arbitral award is against this company, then I think there will be no problem with the enforcement of such award. So this is the so-called principle of effective jurisdiction, which was formulated by the Supreme Commercial Court of the Russian Federation and still maintained by other courts. As regards the grounds for refusal to enforce and recognize arbitral awards in Russia, I would say that indeed the public policy ground is leading still. I think it's the most pervasive. There are various aspects of public policy of Russia. For example, a big problem for the award creditor is if there is already some Russian state court judgment with a conclusion relevant to this dispute and contrary to what the arbitrators decided. So the contrariety to conclusions of a Russian court judgments is considered to be contrary to public policy, because the conclusions of Russian judgments are obligatory, and so other acts, including awards and foreign judgments, should not be contrary to them.
At any level, at any court level, so any Russian judge or any other, or only at the upper court level.
Any Russian judgment which has become effective in force. Then,
okay, so any Russian judgment is public policy, even like of some regional court.
Yeah, any. So sometimes there are parties who try to create artificially such judgment, trying to, for example, challenge the act of public authority, challenge some document which was evidence in arbitral proceedings. So if they succeed in it, then it means that arbitrators base their award on a document which was found null and void by Russian courts. So there is already a ground for such defendant party to say that there is contrariety to Russian public policy. Another aspect of public policy is now popular ground for defendants to rely on is that the arbitrators did not have equal attitude to both parties. that, for example, defendant, some motion or some argument of the defendant was not considered by the arbitrators and not reflected in the arbitral award, or they had no opportunity to present some argument, were denied such right. So there is a due process paranoia by arbitrators. They try to give more opportunity to both parties. Sometimes this means that the proceedings in arbitration become more protracted, and the arbitral award becomes more lengthy, detailed. I think interesting, if the award is detailed and lengthy, there is a better chance it to be enforced in Russia. That's how some arbitrators believe, and perhaps this is true. Another ground for refusal of enforcement is non-arbitrability of the case, and in fact, non-arbitrability is usually when the relations are more public law relations rather than private law relations. For example, when the budgetary funds were spent for the contract, this means that there is too much public element. There is a risk that it will not be enforced, such a word. But fortunately, the Supreme Court, 2 years ago, noted in its judgment that if the relations have international element, like international contract, even if the budgetary funds were spent, but still this may become exception, and this will any award from such contract may be enforced because the dispute is arbitrable. Okay.
That's interesting. Thank you. Thank you very much. And
sorry, but if the budgetary funds were spent by one of the parties in the performance of the contract, or any way even remotely related to the contract?
This means that, for example, it was a public procurement contract where some public authority bought something from the private party and paid with budgetary funds. Then this contract, any dispute from this contract should be solved by state court.
Yeah. Thank you, sorry.
Thank you. Thank you very much. And Richard, what about the BVI experience? Your microphone is switched off.
In the BVI, in principle, the grounds are the same. It's the New York Convention defences that can be raised against enforcement, and the court can, of its own volition, refuse to enforce on public policy grounds. But I'd say that the approach is probably the opposite of that taken by the Russian courts, in that the presumption is certainly in favour of enforcement. And of course, as I mentioned before, the advantage in the BVI is that the courts there don't necessarily take a side in the dispute, as may potentially be the case, particularly where there are state entities involved. The public policy ground is often invoked in answer to applications to enforce judgments, but it's very rarely successful. One example of that is the Chukarova versus Sonera case, which was a very significant piece of litigation, and it was alleged there that the respondent hadn't been able to raise certain arguments in the arbitration, and also that the tribunal didn't take certain evidence into account. And what the Privy Council, which is the highest court of appeal in the BVI, said in that case was that what you have to show for a breach of public policy is that the way in which the award was made would be a breach of the principles of natural justice, which is quite a high bar. And in that case, the defences were thrown out. In a much more recent case, PT Ventures versus Vidatel, which is another very significant case involving a $650 million award from a Paris tribunal, the court took a slightly more nuanced approach in that it did throw out a number of public policy arguments raised, which actually it found were really points of fact or law, and the court isn't allowed to refuse to enforce an award on the basis of an error of fact or law. But that there were issues about whether the actual award should have been annulled. And in fact, the award was subject to an appeal in Paris, in France. And in that case, what the judge said was that there was so much competing evidence as to whether there had been an infringement of public policy, and that it was alleged the tribunal wasn't independent, wasn't properly constituted. He actually ordered that there should be a trial on that point, which is yet to take place, I understand. So that's one example of where raising defences has gained some traction with the BVI court, albeit that it will just take slightly longer to resolve. It's not clear yet whether those arguments will be successful.
Thank you. And we have one question in our chat to Dmitry. Could you give some case reference regarding court judgments becoming public policy once becoming into force? There is a question in the chat from Viktor Rykov. Dmitry, please.
It's not easy to find immediately a judgment confirming it, but I want to make clear what I mean. I mean a finding of a Russian state court on a particular, particular issue, such as, for example, that the underlying contract is void. Let's say that in an arbitration award, the claimant claims damages from a contract, and then it appears that this contract was found void by a Russian court in some other proceedings. So this means that arbitral award for damages out of such void contract will not be enforceable in Russia. That's to briefly say, if I briefly say so.
Thank you. And I think there's a comment and raising hands. Maria, you want to add something?
No, sorry, I just want to ask Dmitry again, but do you mean the decision between the parties? For example, the decision of the state court applying to this particular contract between the parties, right? So not just any decision on a related issue, on an issue of law, for example.
No, not an issue of law, but relating to the same relations. So a document which was as evidence in these proceedings.
Okay. Okay.
Again, we have a raised hand. Mr. Yari Krivoy, you have a comment or question, please?
Yes, I have a question for Jakub about how they take into account the enforcement prospects when they make decisions on whether to fund or not to fund a particular case. Just if you could go through the steps which you have internally.
Well, thank you. This is a good question, and I think the important aspects have been touched upon. Dmitry has set out certain aspects, Richard has set out certain aspects, and it is very important to have everything in mind, and how is it different for a funder as opposed, for example, to a lawyer who assesses a case. Or how is it different in my work as opposed to Maria as she goes through the process from start to the end? Well, I think it's important to remember that when the funder takes a decision, the funder takes a decision at the very start of the proceedings. So we have to think about all these aspects that have just been mentioned by Dmitry and Richard and Maria. We have to think about all these aspects at the very start and to decide then whether these aspects will take the case, will be taken through the case and will lead to a final result where the client will be able to receive a payment, where the award will be enforced, where the client will be able to receive a payment. Because if we receive a payment but the client doesn't, the client will never come back to us and the lawyers will be unhappy as well. So this is one important aspect, that the decision is taken at the very start. And then the other aspect that needs to be remembered is, what does the funder actually do when the funder funds a case? The funder does not provide a loan to the client that would have to be paid back. And I think that's still often misunderstood. And the funder provides non-recourse funding, meaning that the risk that the case is lost, the risk that the enforcement of the award doesn't work, the risk that there are no assets, all these risks, they are transferred to the funder. And the funder bears this risk that the case is lost, that the award cannot be enforced, and that the client doesn't pay the award. So I think it's a very good question, and it's also very good that these aspects are being discussed, because from my point of view, from the funder's point of view, it's you can oftentimes see that the aspects that are being discussed in the review of a case are mostly the legal aspects. And I personally, having worked for so long as a lawyer, I'm prone to this mistake, and I jump at the legal aspects, when oftentimes it's not the legal aspects that are the most important for the case, but it's the question whether we will be able to go with the award and actually have it enforced and actually get a payment. So when we are investing in it, when we are looking at the case, we are not really investing into a case, but when there is a strong enforcement element, we are investing into a legal system. We are asking ourselves, will the courts be with us? Will the bailiff be with us? And so the questions, the aspects that Richard has set out, and Dmitry as well, they are at the very front of our assessment. And it's good and important that we are talking about this topic, because it should be at the very front. Thank you.
Thank you very much. And maybe one follow-up question to you about the funding of the investment cases against the countries. What could you say? Maybe you made some research as a lawyer for third-party funder. Which countries from the CIS would be in more interest to fund the case against this country? With like future decision on that this award will be enforced more easily than in other countries, maybe?
That's a good but very difficult question. It's very difficult to point out certain aspects. Obviously, when we have requested to provide funding for a case against a state, we look very thoroughly at the state itself. We are looking at so apart from the funding application itself, we are looking at the information that's publicly available with regard to this country. For example, does this country, does this state pay voluntarily? If not, have there been successful attempts to enforce awards against the state? And we obviously there are different aspects to take into consideration, and it's very difficult to point out this country will be it will be a successful case and this country will be an unsuccessful case. It's very difficult also to say, because the funding application and the case can be very different. So one case may have a very high amount in dispute and a very low budget requirement, which is obviously better if the amount in dispute is very low, but the budget is supposed to be very high. So it not only depends on the country, but from my time at VEON, I have seen funding requests against basically every country, every CIS country that there is. Of course, it is a very difficult. It's a very difficult decision with regard to these countries when you know that there are so many difficulties in the enforcement. And not only in the enforcement of the award, but actually getting to the final stage where the client is being paid. So in summary, Islambek, I'm sorry, I can't answer your question, at least not publicly like this.
Yeah, thank you.
Have you accepted any such funding requests against CIS countries?
Pardon me?
Have you accepted any such funding requests and cases against the CIS countries?
We do fund cases against states, yes.
In the CIS region?
I would be limiting myself to
sorry.
if I said against which countries.
That's a very interesting question, and why was I mentioning that? Because in my practice, I have represented for the last 2 years Uzbekistan in the investment cases, and in each case, in my practice, there was always the third-party funder who were funding this case and were looking for the enforcing of the award in the future. But we made some analysis during my work at the Ministry of Justice, and it's maybe easier to enforce against the Uzbekistan than maybe enforce the award against the Kyrgyz Republic or Turkmenistan. So because these countries, they don't have much assets in foreign countries, and so it's harder to enforce in the country, and there is no assets in foreign countries. So there could be an issue to find the asset and to find the place where you can enforce the award. So because of that, I think a lot of third-party funders are interested to fund the cases against Uzbekistan, in my point of view. And there is a question, Jacob, about in the chat box to you. The question is, what extent do funders use award default insurance to mitigate enforcement risks in arbitration against states? There's a question from Evgenia Rubinina.
Sorry,
She may actually ask this question using voice, if Evgenia is happy to do it.
Please.
Maybe not.
Maybe it's not possible, but I'm happy to say to offer my opinion on this. So I'm not sure if we are talking about the same thing when she says award default insurance. So what I understand this to be is an insurance that if the award cannot be enforced, that there will be an insurance payment made to the client or the funder. It depends then on the constellation. And we, as a very short answer to this, we do work with insurance companies, and we include these insurance solutions in our work. And these insurance solutions, I think what is probably mostly known is the after the event insurance, by which we, for example, would say the risk that the case has lost is transferred to us, and then if our client is ordered to pay the adverse costs, then we would cover these adverse costs up to a certain amount or to an unlimited amount. So this is one solution, insurance solution that's publicly known that funders work with ATE insurers. We do also use other insurances. So if there was an award default insurance to mitigate enforcement risk, we would absolutely take this into consideration and would absolutely work with such a solution. And Evgenia, maybe just an overall comment. I think this is what when it comes to enforcement, this is what funders are actually looking for, that there is a strategic and also maybe not typical, but that there is a thinking outside of the box where you can use different aspects and different solutions to come together and mitigate the risk that the case is actually lost. I hope this answers the question, Evgenia.
Thank you. Thank you very much. So if there will be any other questions, we will raise that. And to follow these discussions, Maria, maybe you will also share with us, with your experience in the enforcement of arbitral awards and maybe in the enforcement of interim measures. Did you have some experience on that and in your practice?
I did, not only at VEON and not necessarily at VEON, but yes, actually interim measures is one of the important tools for obvious reasons in the subsequent enforcement of any decision, arbitral decision or court decision. It's not always easy to enforce though, and I know that recently more and more jurisdictions have been accepting that interim decisions, interim orders of arbitral tribunals can be enforced. But I think it's still an issue in some of the CIS countries, whether it's because the interim order is not considered to be an award on the merits, or because it's not a final and binding order, or maybe because such an order is sometimes for specific performance. And this is something that can be difficult. So you can always, your lawyers can always tell you, yeah, okay, we'll ask for interim measures, but then it depends what the interim measure is and which is the country where you expect to be able to enforce it. Fine, in the arbitral context, in most cases, the other party doesn't want to antagonize the tribunal, so very likely they will try and comply with the order, but it's not always the case. So sometimes you need to evaluate whether you can actually get something tangible out of this interim measure. And if it's a specific performance order, whether such a specific performance is actually allowed by the country where it is expected, because in some of the civil law countries, there can be an issue. And also, what if they don't comply with such an order? Is there a sanction? So in common law countries, you will have contempt of court, for example. In some civil law countries, like in France, you can have astreinte for every day when you don't comply with a specific order. But it's not a case in all the jurisdictions. So I think it's another, we're used to think that interim measures are a very important tool, but you have to assess whether it will actually be an effective tool in your particular case, given the country where this interim measure is expected to take place. Mm-hmm. And I don't know if Richard, for example, can offer any perspective on the BVI approach to enforcement of interim orders and specific performance orders. That would be very interesting.
Richard, maybe you will follow up on your experience with BVI.
Yes, I'm not aware of any decisions of the BVI court enforcing an interim order for specific performance. And I don't know how the BVI courts would approach that, to be honest, because specific performance is pretty close to a final remedy, depending on the nature of the case. And obviously, if a tribunal has made a specific performance order, and that is a final order, albeit on an interim basis, then that prima facie would be enforceable by the BVI courts under the principles of the New York Convention. But I have to confess, I've not seen those kinds of interim remedies sought to be enforced in the BVI. The sorts of interim remedies we do see very frequently are freezing orders and disclosure orders that go with them. And you mentioned the consideration, which is obviously a very important consideration, is how do you actually enforce those orders and make sure that not only are they complied with, but also that they produce you results which actually bear fruit rather than simply being a Pyrrhic victory. There was a very interesting case about this earlier this year in the BVI called Donna Union versus Kashigi, which involved a dispute over a major Russian retailer, Walmart Holdings. And in that case, measures were sought on an interim basis to prevent dissipation of assets prior to the granting of the final award on quantum, because the respondent had started to dissipate its assets, and there was strong evidence of that. And they'd even, in fact, taken the step of re-domiciling themselves from the BVI to Anguilla in a desperate attempt to avoid the enforcement of this award. And the BVI court took a very robust approach and not only granted freezing orders and disclosure orders that went with it, but when the respondents failed to give proper disclosure, and obviously in the light of the steps that they were taking to avoid enforcement, the court went further and appointed a receiver. And of course, the receiver is a much more draconian remedy than a freezing order, because it actually puts an independent person in control of the company. And in my view, a freezing order can often be one of those remedies which is a Pyrrhic victory, because it may actually not achieve the result that you want. But a receivership order very often does achieve the result that you want, because it's such a strong measure and effectively removes control of the company from the directors of that company, and gives the receiver the ability to go and actually get in assets and, crucially, I think, obtain information which can be really useful for the purposes of enforcement. And so, although freezing orders and receivership orders, in my view, are very important, to my mind, in the context of international arbitration and in the context of offshore financial centres, it's the disclosure orders that go with the orders which can really produce the most sort of effective results, because you can force the disclosure of information which may then lead you to assets that you didn't even know existed, which may be in places that are more easy to get hold of. So, for example, if there's real property in London or continental Europe or something like that, that will be much easier to enforce against than, say, assets that may be within the CIS or still offshore. So to my mind, the message from the BVI courts, particularly in the Donner Union case, is that they won't tolerate parties who don't comply with interim measures, and that they will grant increasingly draconian measures against those who do fail to comply. And as I say, it's the disclosure element of these measures which I think can be some of the most powerful weapons.
Thank you very much indeed. And Dmitry, what about the Russian courts' experience in that? Maybe you can share with some cases.
I represented once a Vietnamese company whose assets were seized here in Russia by Commercial Court of Moscow in favor of judicial proceedings in Vietnam. So there were proceedings with a large reputed Russian bank in Vietnam for damages or some debt from that Vietnamese company. And the Russian court, upon request of the bank, seized its assets here for the period until the end of the proceedings in Vietnam. So we managed to lift this freezing order, but still, interestingly, that Russian courts agreed that it existed at all, so it's possible. Also, I know that there are cases where, for example, the arbitration took place in LCIA in London against the Russian businessman, and his assets here in Moscow were seized, such as his apartment, in favor of arbitration in London. In general, it is possible to obtain a freezing order or some other interim measures here in Russia, as you see. But the threshold is rather high to prove that there is a risk that the money will be, and the other assets will go away. So, of course, no guarantee, but there is a chance to do it.
Thank you. Thank you very much indeed. And if we will maybe continue discussion relating to the third-party funders, Jacob, what could you say about maybe the main risks of the third-party funder in the process of the recognition and enforcement of the award? And maybe you could describe how the third-party funder goes through the process of assessing the risk of enforcement before deciding whether to fund the case, and what are your main criteria in the review of enforcement risks, and maybe also in the issues of the interim measures.
Yeah, thank you, Islambek. Well, I touched upon it already, and maybe I can go into a bit more detail there. So first of all, we look, of course, at the funding application, and we are trying to assess whether the case strategy is a sound one. So we look at the amount of dispute. What is the client actually trying to get? we are looking at the budget, and I think it's common knowledge that every funder requires that the ratio between the budget and the amount in dispute should be 1 to 10, because if the budget is higher than 10% of the amount in dispute, then it becomes too costly for the client to actually go through with the funding. So we look at the, like I said, amount in dispute, we look at the budget, and we look at the duration of the case. And when you look at the duration of the case, of course, that's when the question of enforcement and potentially annulment proceedings, set-aside proceedings come into question. And not only having the award declared enforceable is one step, but also take the award and have it actually enforce it, so get to the recovery. This all influences the duration of the case. And as you know, the duration of the case, the longer it goes, the lower is the return for the funder. So this is a very important aspect. And when you look at these three variables, then you can determine what the rate of return will be on the investment. And then we also look at the, like I said, we're looking at the case strategy, and this is where where it becomes really interesting, because this is where the lawyers show really the brilliance and say, so we will go forward with an award, and we will get an award in, say, Germany, but we will enforce it in Russia, in Kazakhstan, and in China. And this is actually the very interesting part as to how the very clear-cut arbitration process will then go into the enforcement stage. And maybe I can mention one or two examples. And there was one case that we looked at, and it looked very solid from the legal aspect, and it looked very solid as well from the other aspects. So we looked at the issues that I mentioned before. What is the publicly known information about the country where the award will be enforced? What is the other information that we have? And this award, if successfully obtained, would have to be enforced against two power generation units, so two power plants, which at the outset it looks very good because it's immovable property. Nobody can take their power plants away and run to a different country with them. So we had an asset tracing company look into this, and when we looked into these power plants, so we saw that under the company holding the power plants, there was a myriad of companies, of subsidiary companies, and we saw that the assets were regularly moved between the subsidiaries. And we also found out that the managers of these companies were regularly changing from one company to another. And there were indications that the management was actually moving money out of these companies to offshore accounts, or to somewhere which we could not establish. But in any case, one of these managers of the company was indicted of embezzling several million of euros, not euros, several million of the local currency. And this was obviously a red flag for us that we looked deeper into. And then we found out that the management of these companies, that they are also very closely related to diplomatic staff in the country, that they were driving around in cars with diplomatic number plates. And this is where it gets then really tricky, because, you know, even if you can get to these power plants, will you be able to enforce it? Like I said before, we invest in the legal system. So we had to assess the legal system. Do we believe that the legal system will provide us with the means to go after the assets despite the fact that the people that will be at the center of this are very closely, very tightly in very close connections to very powerful people in the country.
Thank you, thank you. And I really remembered one case. There was a case for more than $1 billion US, and which was in ad hoc, as I remember, for 2 or 3 years, but the award was only for 10 million. And the third-party funder tried to enforce it for the last maybe 6 years, yeah, 6 years, and wasn't able to enforce it in several jurisdictions during this period of time. And then it was amicably resolved. What do you think in this regard? Was the third-party funder able to get profit or to recover its costs, having this award and trying to enforce this award in many jurisdictions? In your opinion, maybe in your view?
Well, obviously, it's very difficult to assess it from this bird's eye perspective, but if you run enforcement proceedings over several years in several jurisdictions, and the potential amount that you can get out of it is $10 million, it's difficult to see how this would be a profitable endeavor. So I can't at the outset, I don't see a profitability there, but of course it will depend on what has been agreed with the asset tracing companies, with the lawyers, what has been agreed with everyone involved. And like Maria said before, not every measure that's taken is taken for should be taken at face value. So maybe the enforcement of this 10 million award was taken to get to something else in a parallel case. I can't assess that from this perspective.
Yeah. I think I remember this case because of I saw a lawyer who also participated in this arbitration case around our participants. Maybe there will be a question or comment by him. Thank you for your answer, Jacob. And I would like to ask the question from our speakers about the enforcement, maybe recognition and enforcement of arbitration awards with the moral damage. Like if the arbitration award have the moral damage, will it be recognized and enforced by the state courts of the CIS countries and maybe also in BVI? What do you think about that? There was an issue on that also in one of the Uzbek cases against Uzbekistan, because there was an issue with the moral damage and there was a question on that. So Dmitry, would you like to begin?
Could you clarify, Islambek, to whom do you mean moral damage to an individual or what?
Yeah, the moral damage was to individual person, yes. The foreign citizen, maybe.
I think that this is quite possible because, well, the mere non-existence of some rules, for example, or even in Russian, Russian law includes notion of moral damage, compensation for it, so there is no problem. Even if it was something non-existent in Russia, this is not a ground to refuse enforcement of the arbitral award. So I think that yes, but the only exception is punitive nature of of damage, or something like is known in the United States when the amount of damage is exorbitant, many times more than the loss suffered. Then we have quite an established case law against the enforcement of such punitive damage, that Russian courts many times confirmed that this is contrary to Russian public policy. unfortunately, usually they just refuse to enforce it in its entirety, not in part, because they find that if they assess themselves the amount of damages, then this is just a review of the award on the merits, so they don't do it.
Maria, Richard, would you like to add something on your experience on that?
In my experience, I've seen that claimed, but I haven't seen any decisions in the CIS which actually accept the moral damages. But look, I haven't conducted an exhaustive study of all the court cases. So
I've never seen that kind of award attempted to be enforced in the BVI courts, but I could see that there could be real difficulties with that because the principle of moral damages isn't one that's readily recognized in the BVI, and it sounds as if it would involve the court considering whether the moral principles involved were the same sorts of moral principles that BVI law would take into account, and therefore it would effectively come down to a question of BVI public policy. So I think there would almost certainly be difficulties with enforcing an award of that nature in the BVI.
Yeah, because regarding such an award, there was an issue with the challenging of such award because there was a question: does the arbitral tribunal such competence of the awarding moral damage? Because it's not commercial, and this is an issue, and there was an issue of the challenging of such recognition and enforcement of the award, because one of the parts, they were thinking that the arbitral tribunal, they didn't have a competence for that, for the awarding of the moral damages, and that one was the issue also for challenging, and also for challenging the enforcement, recognition and enforcement, maybe just in this regard. So this is an issue because it is also discussed in the ancestral working group, ISDS reforms, in the third working group, on the competence of the arbitral tribunal in the investment cases and also in the commercial cases. So if you have any opinion on that, or would like to add something about the enforcement of the arbitral awards and the foreign court awards, I would be very glad to give the floor to our speakers, and maybe there will be any comments from audience, please. And the main issues was about the enforcement, and I think we have one question in the chat box from Sergei Alyokhin. He is commenting on the Uzbek award mentioned by me. The 10 million USD figure is without interest. The interest was ordered to run from 2004 annually, compounded. It depends on the legal fees, really, as Jacob mentioned. In that case, the legal and arbitration costs were slightly under 10 million, not counting the years of enforcement. But if we will count the years of enforcement, we can tell that the third-party funder couldn't recover his costs. I think
it's like bad business.
Yeah.
Yes. Sorry.
Bad luck.
This is Sergei Alyokhin himself. I do have a voice. It was just to sort of set the record straight, really, Islambek. It was a funny case that I was involved in, not during the enforcement phase, but for the vast majority of the underlying arbitration. And indeed, the outcome was effectively on par in terms of the amount awarded and the amount spent on legal fees and subsequent years of enforcement.
Thank you, Sergei, for your comments. I'm very glad to hear you. And could you maybe, I would like maybe ask you why this third-party funder didn't come to Uzbekistan to enforce its case, its award.
I left that firm before the final award was issued, so I am not privy to
Okay.
the strategy of enforcement, I'm afraid.
So third-party funder didn't come to Uzbekistan and try to enforce so everywhere, but not in Uzbekistan. There was some issues because of that. So this is also sometimes the issue, but this is the thing when the claimant would like to go to international arbitration to enforce it in foreign countries, not in that country. So this is his right. And please, if we have any other questions, there is a question from Mr. Sam Colles, University of Law. Question for Jacob: how long does it generally take to assess the risk of enforcement? Are you able to give the client an answer as to whether they will secure third-party funding in a relatively short period of time?
Thank you, Sam, for this question. Well, it depends on what you understand to be a relatively short period of time. I think a typical process where we assess not only the enforcement, but assess the entire case. So from the legal aspect to enforcement recovery it takes about 6-8 weeks until we have a decision whether we want to whether we can go forward and actually present it to our investors, who will then take a decision whether to fund the case or not. We have seen cases where the decision, so from the funding application to the signing of the litigation funding agreement, was 3 weeks. But that was shortly before Christmas, and so it had to be done really, really quickly because the limitation period was running out. So 3 weeks is a lot of sleepless nights, but it can actually be done in that time. But it's very atypical. Like I said, the typical time frame is a bit longer, and then the more complex the case is, the more complex the strategy that is suggested for the case, the longer it takes. So if you have a complex case where you would like to start enforcement in 4 different countries, and we have to speak to asset tracing companies in 4 different countries to assess whether the assets are there, whether they can be attached, it would probably take even longer than that.
Could I ask a follow-up question, Jakob?
Yeah, go for it.
Do you as a funder, or are you aware of other funders who buy awards and then take the enforcement process from there?
Yes, I'm aware of other funders doing it. We are quite hesitant to do it, typically, mostly because of a psychological argument. Typically, it's best if the client retains interest in the case. Retain skin in the game. Otherwise, if you pay out the client and the case transfers to you, but you don't have access to the documents, if you don't have access to witnesses, you don't have access to the people handling the case, that actually creates certain difficulties. We do actually do it in exceptional circumstances where the amount in dispute is quite large. So more than $100 million. This is something where we would take it into consideration, but not for the typical case, 10 million upwards. It will probably be difficult to find an alignment of interest there.
Yeah. Okay.
And if you are unhappy with the level of risk, are you able to offer it to other third-party funders? Would you assist the client in finding someone else, or does that ever happen if you're uncomfortable with it?
Pardon, I didn't understand the question. If we are happy with the level of risk,
if you're unhappy with the level of risk that's presented with the case, are there other funders that you would recommend?
Oh, absolutely, yes. That's a very good question. So when we look at, especially with regard to enforcement, when we look at the enforcement aspect, like I said before, we don't necessarily invest into a case, we invest into a legal system. So if we were to go forward with a case, say against the Ukraine, we would have to have the understanding that this case, we can enforce it in Ukraine. Now, if we get a second, third, and fourth application for funding of a case against the Ukraine, then at some stage we would probably say, look, we have a certain concentration of risk in cases against the Ukraine. So even though the case looks good on the legal and on the enforcement area, we don't want to have this concentration of risk, and so we then start declining the cases. And then, yes, we are absolutely capable of pointing you to other funders that are capable of funding the case and have the knowledge and experience in the region, Russia, CIS as well.
Thank you. Mr. Yarikova, you raised your hand, please.
Yes, thank you. I actually have a question probably for you, Islambek, based on your experience working for the government, or maybe others will have views on that as well. I was wondering whether you have any thoughts on enforcing court judgments in cases which involved corruption. So let's say certain assets were stolen from the country, were tunneled abroad through corrupt schemes, and then they end up in Western jurisdictions. Have you had any experience, or are you aware of any interesting cases in that respect? So how easy it is to enforce? Are there any peculiarities? I'm doing a project now with the UN Office on Drugs and Crime, where we look at corruption and foreign direct investments and what sort of approaches can be adopted on international level to deal with corruption-related proceeds hidden abroad. Mm-hmm.
I would like to clarify. I'm interested in the enforcement of the decisions of Uzbek courts, which are enforced in foreign countries.
Mm-hmm.
Yes, I have worked on such cases, but I'm not maybe capable to talk about that in details, maybe just in main interesting situations. There was an interesting situation in France when we enforced it in France, in Paris. It was a Paris court. There was an assets. There was flats, some houses, and when we enforced it, the court recognized and enforced this Uzbek court's decision. It was bringing back to Uzbekistan the assets and the money which were granted maybe with the corruption, etc. As you mentioned, in this regard, the Paris, they enforced it, but when we asked to transfer it to Uzbekistan, the regulation, they mentioned that there is a regulation that these assets should be sold and the money give to Uzbekistan. So we got only the money, and there wasn't possibility to get the asset itself. In Latvia, it was easier. We got the possibility to get everything, also the bank accounts, the assets, flats, etc., etc. It was just transferred. There was a decision also of the state court of Latvia, and we did it easily. In some other European countries, there was an issue, and still an issues, because there is some regulations related to corruption, and it's really a little hard to enforce, to recognize and enforce these decisions of Uzbek courts. And as I mentioned, I can't tell the details of such cases. And also there is an issue with the cases related to US, because US has its own regulations and trying to freeze some assets and accounts in EU countries, in several EU countries, and discussing some and including some political issues in the recognition and enforcement of the decisions of Uzbek courts in these EU countries. Maybe in future I could give some more information on that, or you can make some research in the official websites of the state courts of these countries to get more information. But as I mentioned previously, I'm not able to speak about that, even if I was involved on that. And
yeah, that is already quite helpful and interesting. Yes, yeah. And one of the problems is that very often these cases are seen as political. So essentially, the person who is the target is saying, well, the reason I am targeted is because of my political views, because I'm a member of the opposition. And then the courts have to decide, is it true or is it not? And then also the countries may be not willing to give up this money because this involves significant assets, maybe damage to the economy. And one of the things which they are considering within the UN Office on Drugs and Crime is whether to have some sort of independent dispute resolution mechanism involving states, but it's quite a sensitive topic. Thanks.
Thank you. So, colleagues and dear participants, is there any other questions or comments on discussed topic? The time, I think, is also coming to the end of our panel, and I would like to thank everyone, to thank our distinguished participants and our distinguished honorable speakers. Thank you very much for your speaks, for sharing your experience. It was really very interesting. It was really interesting even for me, and I tried to write down, and I think the possibility of this video will be given to watch it again. And I would like to thank the organizers of this event, CIS Arbitration Forum. Thank you very much for the organization, and thank you to all participants and who participated, asked the question, and also heard this speaker's speech. Thank you very much, and hope that the next time we will be able to see each other in person.
Thank you very much, Islambek. Excellent panel, and I certainly learned a lot. We can see that there's a new speaker joining us, a very young one. So we now have a 15 minutes refreshment break, but please feel free to chat. I think Dmitry was very good in asking questions during the breaks, and so that it's not complete silence. But we will officially resume in 15 minutes.
Thank you.
Okay. I just recall a case in Russia in Maritime Arbitration Commission at the time when I was tribunal secretary of Russian two arbitrators, where it seemed to be a completely straightforward case, contract of affreightment of a sea vessel. The claimant said that all is very simple. I provided the ship and the defendant did not pay for it in full, but paid in part. And this was completely confirmed by all documents. And it seemed to be absolutely obvious case. But then we obtained the statement of defense, and the argument was single alone, that, well, the contract was procured by the claimant through corruption. With kind of corruption, that the founder of the claimant, the main shareholder, was, as far as I remember, the daughter of the general director of the respondent, the former general director, of course. So therefore, the contract was not on market conditions, but was in favor of the claimant. And the respondent had an opportunity to conclude a contract with another persons on market conditions, but did not do it because of these family ties. And then the respondent produced a criminal sentence against their former director general exactly about this particular contract. So then the respondent argued that they paid only the part and did not pay the difference which was exactly obtained due to these family ties. So the arbitrators thought together this situation and found that indeed, if there is a criminal sentence confirming these allegations of respondents, so they decided against the claimant on this argument. So sometimes criminal sentence is used in arbitrations as well, and on enforcement stage also.